Good evening. It's a pleasure to be here, and it's great to see so many people in the audience. And I want to thank particularly Steve Ross for putting this together, and can't tell you how delighted we are to have him now in our community at the University of Washington. What I'd like to do today is just give you a very brief introduction to the Innocence Project Northwest and to the phenomena of wrongful convictions and what we've learned through especially the 284 DNA exonerations that have taken place since DNA began to be used not only to incriminate people but also to exculpate them. I'm going to touch also upon the 4 cases that Paula mentioned in her introductory speech, the 4 people who have been exonerated since 2008 and who the Innocence Project Northwest was actively involved in working on their cases and litigating those claims. So the Innocence Project Northwest began in 1997 at the University of Washington Law School. Initially, it was a volunteer organization, so everybody who was working on the cases volunteered their time. So law students, attorneys, professors, and we were primarily working on a large group of cases known as the Wenatchee sex ring investigation cases, which occurred in 1994 and 1995 in Washington State. Since 2002, it's been a clinical law program at the University of Washington School of Law. And so I and other staff attorneys work with law students, many of whom are here this evening, I'm pleased to say, on cases of people who say that they're incarcerated in Washington State for crimes that they did not commit. We do both cases where there might be potential for DNA testing to prove that the individual is innocent, and we also take cases if there is non-DNA evidence that may show that the person didn't commit the crime for which they were convicted. So each year, 10 to 12 students will work on cases of people who, again, are in Washington State, who say that they're innocent of the crime for which they've been incarcerated, who no longer have the right to appointed counsel, so they really don't have any other recourse, any other way of accessing the legal system other than our project, and who say that they don't have any involvement in the crime for which they've been convicted. We don't take cases of people who are claiming self-defense. We don't take cases of people who are claiming it was a consensual act of a sexual act that was consensual if it's a rape case. And we don't take cases where someone is saying I should have been convicted of murder 2 instead of murder 1. The person has to attest that they did not have any involvement in the crime for which they were convicted. And we look at cases of people who are indigent and can't afford a lawyer, which unfortunately in our prisons is not really very much of a barrier to our cases since most people are indigent. So in terms of what we know about the number of people who have been in prison for crimes that they didn't commit, I started doing this work in 1997, and quite frankly, I'm surprised that I'm still doing this work and that there's still so much work to be done, because what we've seen is really a phenomenal increase in the number of exonerations in the recent past. 284. I think there was an additional exoneration since Paula looked at the website. I had to check it today, and who knows, it might be 285 by the time we're done with this talk. But 284 people who have been proven to be innocent through scientific testing of crimes that they did not commit. When I started the work in 1997, it was at 42. So the potential of DNA to exonerate people has really increased because the testing has gotten so much more sophisticated. And whereas in the 90s you needed a fairly large sample of biological material, now you can do testing on samples as small as 30 to 40 skin cells. So it's really improved the ability to go back and test in cases which you couldn't test previously. There's also been a number of people who've been studying non-DNA as well as the DNA exonerations, with Professor Sam Gross at the University of Michigan leading the effort on this front. He did a study in 2003 in which he had identified 389 exonerations. He's been working on that steadily since 2003, and now the preliminary results have identified 850 exonerations that have occurred from 1989 to the present. They include those DNA exonerations that are listed above, but the rest are non-DNA exonerations. And they do not include the around 400 cases of people who have had mass exonerations, such as the Wenatchee cases, or the cases in Tulia, Texas, that you may have heard about when a rogue police officer was prosecuting or arresting, and a number of African American people were convicted of bogus drug offenses. They don't include the LA Rampart cases where the police were planting evidence on suspects. So it's really a significant number. And what we've learned about what leads to wrongful convictions are that these factors, mistaken eyewitness identification, coerced confessions, unreliable forensic laboratory work, police misconduct, prosecutorial misconduct, ineffective representation by counsel, either working on their own or working in concert with each other, are the leading causes of wrongful convictions. And here's a chart of the first 225 DNA exonerations. I don't know if you can read in the back, but you see that big bar on your left-hand side, the 77%. That represents the number of exonerations that had mistaken eyewitness identifications. It's known to be the leading cause presently. It was known to be the leading cause back in the early 1900s when the first study was done. It consistently appears in every study as the remarkably largest contributor to wrongful convictions. Other leading causes include unvalidated or improper forensics at 52%, false confessions at 22%. So if you think about that, 1 out of every 4 of the DNA exonerations involved a false confession or incriminating statements made by a suspect who ultimately turned out to be innocent, and 16% involving informant testimony or jailhouse informant testimony. And what we found from our cases is that these numbers play out in about the same way in the 4 cases that I'm going to talk to you about tonight. So we have pictured here Ted Bradford on the day that he was exonerated after serving almost 10 years in prison for a crime he did not commit. James Anderson and his now wife Hassani, pictured here at the Innocence Network conference. James served 4 years out of a 17-year sentence for a crime he did not commit. And Alan Northrup and Larry Davis, who served over 17 years in prison for crimes that they did not commit. So starting with James's case, James was actually in Los Angeles, California, when a series of robberies took place in Pierce County during April of 2004. He was extradited from California and charged with committing one of those robberies that had happened on April 12th. He was able to get probation records showing that he had been reporting to his probation officer in Los Angeles at the time that the April 12th Tacoma robbery occurred. And so that charge was dismissed, but then rather than being released from jail, he was charged with a robbery that was alleged to have occurred on April 8th at about 4 in the morning. James ended up representing himself at trial, and he tried over and over again to get probation records showing that he in fact was in Los Angeles at the time that the April 8th robbery occurred as well. So he asked the judge, he asked his standby counsel, he asked the investigator, he tried to subpoena the records himself, but the LA department wouldn't turn them over to him because he was the probationer. So he went to trial without the probation records, but with his girlfriend testifying that he was in LA. He was convicted, and we took on his case in 2008. We, and I say we when I actually meet Boris Reznikov, one of my law students, was able to call the probation department tell them what we needed, and shortly after we got this document, which is kind of hard for you to read, I think, but it shows in the highlighted part here that on April 7th, 2004, at about 4:45 in the evening, defendant reported in person and was instructed to return. So less than 12 hours before the robbery for which he was convicted, he was in Los Angeles reporting to his probation officer. And believe me, that's a really good alibi to have. Girlfriends, grandmothers, spouses, not so good. Probation officers, excellent. So if you're ever going to get accused of a crime you didn't commit, make sure you've got your probation officer next to you. So when we presented this evidence to the Court of Appeals, they overturned the conviction. And I don't know if you remember, there was a huge snowstorm in 2008 on Christmas Eve back on this side of the mountains. And so the Pierce County prosecutors did work with us in expediting an order to get it to Walla Walla in the snowstorm in order that James be able to be released on Christmas Eve. His counselor drove him from Walla Walla to the Tri-Cities so he could catch a flight and be home to spend the first Christmas in nearly 4 years with his family in Los Angeles. So his case involved informant testimony. There were people that were testifying against him that were given a deal in exchange for saying that they'd overheard James say some things about having committed the robbery. Ted Bradford. Ted was 22, working with 2 young children, living in Yakima when he was arrested and charged with having committed a rape and a burglary. And Ted was taken into the police station. He was accused of committing this horrific crime. It was a home invasion where a young mother was accosted and sexually assaulted while her child was with her, and the child was crying and screaming, and the perpetrator even made some comments about the fact that the kid was a spunky kid. And the police focused in on Ted as their suspect, and so they brought him in for questioning, and he denied having committed the crime. He told the police that he had been at work. He was working steadily 6 a.m. to 4 p.m. during that time. They told him that he was lying. They told him that he had to tell the truth. They told him that he wasn't going to leave the room until he told them what they wanted to hear. And so after over 8 hours of interrogation, after being told that he wasn't going to be able to leave, after being told, after denying, after actually being told that there was DNA evidence and thinking, okay, well, if there's DNA evidence, they're going to find out it wasn't me, Ted gave in. And he told them what they wanted to hear, that he had done it. He then gave a taped confession which did not match many of the details of the crime. Despite being asked repeatedly, was there a child in the room, Ted said, no, 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 no. And there were many other inconsistencies between the very detailed description that the victim had given and the forced statement that Ted gave after 8 hours of interrogation. We started working on Ted's case in 1995. We didn't start working on Ted's case in 1995, but he was convicted in 1995 and he was exonerated in 2010. We started working on it in 2002. And what I have here on the slide is a mask, and this mask turned out to be really critical in his case because the perpetrator had brought it to the scene of the crime and had placed a piece of black electrical tape across the eye holes of the mask. And that tape was still intact. It hadn't been touched. It hadn't been tampered with. And the scientists at the Washington State Patrol Crime Lab very carefully conducted DNA testing on that tape, which proved to be very significant. So they lifted the tape and got a profile, a male profile from the sticky side of the tape that was placed against the mask, and that profile did not match Ted. They also got a profile from the part of the tape that was sticking out of the eye holes, which was significant because the perpetrator was pushing the mask down on the victim's face, and that matched the other profile but did not match Ted. And the conclusion that the court reached was that it was likely that the perpetrator, the male profile on the tape was the perpetrator's. And so Ted's was the first conviction in Washington State to be overturned on the basis of post-conviction DNA testing. The prosecutor retried him based on his confession, despite the fact that the DNA testing didn't match him, and despite the fact that he had alibi witnesses to say that he was in fact at work on the day of the crime, and that they remembered him being at work on that day because they had teased him about a medical procedure he was getting later on. But he was acquitted in February of 2010, and that was the picture that you saw of him right after he heard the verdict. Larry Davis and Alan Northrup were convicted in 1993, and we started working on their cases in 2001. It took almost 9 years to get their exonerations. Part of the problem was that when we first asked for DNA testing, the statute as it was written in Washington State allowed the prosecutor to make the decision about whether or not testing should go forward. And the prosecutor said, no, we won't agree to the testing. So the statute was changed to allow the judge to make the decision. And here I have to report that the Washington Association of Prosecuting Attorneys was in favor of that change. So they agreed that it should be in the hands of the court and not the prosecutor. And the judge allowed the testing, but it still took many, many years for 27 items of evidence to be tested. And Larry and Alan's profiles were nowhere on any of the items tested. What turned out to be significant in their case is that the way that the attack occurred is that two men broke into a home where a house cleaner was cleaning the house. And she struggled with them. They pinned her down, and there was a dark-haired perpetrator and a blonde-haired perpetrator, and the dark-haired perpetrator raped the victim while the blonde-haired perpetrator held the victim down. So the victim eyewitness testimony was the only testimony that ended up identifying or placing Alan, who was supposedly the dark-haired perpetrator, and his friend Larry, who, since he was his friend and had blonde hair, had to be the blonde-haired perpetrator, as the individuals who committed this crime. And Steve is going to talk to you more about the flaws in the eyewitness identification. But I just want to let you know that it was such a struggle to get, it took so many years to get these guys the justice that they deserved. And what ultimately ended up proving compelling in their case was that there were two profiles that were found underneath the victim's fingernails, so two male profiles, which matched her description of how the attack occurred. And one of those profiles matched the profile found in her pubic hair combing, which could have only come from the rapist. So on July 14th, 2010, Bastille Day, Larry and Alan were exonerated. The charges against them were dismissed. And I can't tell you what a great honor it is for me to be able to introduce Alan as our next speaker, but I also want to let you know that you have a special privilege and surprise because Ted Bradford is also with us tonight, and we, Alan and I, have asked him to come up and join Alan for this presentation. So Ted, would you please come up?